It's not in the face! Thank you.
Hello and welcome to Hey Not the Face with your host John Nash and your producer me, Steffi Haynes. And today we are going to give you a primer for not one but two congressional hearings. The first being, well, actually, it's two hearings, not congressional. Only one is congressional. The other one is antitrust. Now, the first one we're going to talk about is the UFC antitrust hearing tomorrow. That is basically about discovery or lack thereof. And the second is a congressional hearing about the new proposed Ali Act changes. Now, you probably can hear that my voice is not what it normally is, and that is because I've been very sick for the past week and a half. So if for some reason my voice gives out, John will continue along without me, but I think that I'll be able to get through this. Now, before we get started, I would advise that you please subscribe. This gives you an opportunity to have whatever is behind the paywall. And it gives us the opportunity to, keep the show going. So without any further ado, let me introduce my host, Mr. John Nash. How the heck are you?
Apparently better than you. That's the word on the street. Now, hopefully you can survive, because if you have to abandon the show and I have to go solo, I think people are well aware this could be a disaster, but we will try to work our way through this.
Absolutely. I think I'll be able to get through. I may have to mute myself a little bit. I may have to stop for a moment, but I think I'll be able to get through. So let's get started, because there will be a hearing in the UFC antitrust case tomorrow. What's it for? What's it about?
Well, tomorrow there's two hearings, actually, to be specific, for the UFC antitrust case. First, there is a conference with Magistrate Wexler, who's the conference on the case, on the pending joint search terms and discovery. And after that, after they meet with her, there will be a hearing with Judge Boulware regarding a bunch of motions. So it's a big day. In fact, tomorrow, because the show comes out on Wednesday. See, I can't even keep KFAB going on the show that I know what day it is. But Thursday is going to be a big day for MMA, for boxing, for combat sports. And it'll be actually a potentially massive day, which I am not sure it's either event, but specifically the hearing that's going on, in the two hearings, the status conference and the meeting with the magistrate, if they're getting enough attention. Now, I filed a non-party request for remote access to the hearing and to both the status conference and the magistrate hearing. I will find out tomorrow, or today, I guess, today before Thursday, if they'll allow me to attend remotely to watch the proceedings. We'll have someone witness there. Otherwise, I am tracking down people that went to the hearings. Fortunately, there's a few people I know in Vegas that go to these hearings, and I can get information. But I'll get the details then for us on the show that will come out to you, the listeners, on Friday. But this is a massive hearing, because there's a lot to be decided here. As you hinted, these hearings are going to be, a lot of it's over the spoilage, as they call it, the lack of evidence that's been provided by the UFC. And that's important, because there's many cases, I should say many of the, as the proceedings go, there's much that are asking about. They need information on the discovery. Specifically, we'll go through, I guess, as a recap for those listening, might not be aware, might be a first-time listener, not as nerdy as most of you people out there that follow the cases with us. There are currently 3 potential class action antitrust suits that have been filed, and they're trying to get class action status against the UFC. This comes on the heels of the previous case, the Lee v. Zuffa, named after Kong Lee. So Lee et al. V. Zuffa, which was settled, and the fighters got $375 million. And I think almost all the fighters have now got paid. I talked to a bunch of fighters. They got their payments. So that was the previous suit. These are the new suits, and they are Johnson v. Zuffa, which is almost identical to Lee, but covers from the period where Lee stopped. So it starts from July 1st, 2017 up until today, and is ongoing until they put an end date to when that class is covered. So anybody who fought in the UFC from July 1st, 2017 through now would be in the Johnson class. The exception is, which is covered by the Cirkunov v. Zuffa case, named after Misha Cirkunov, is that a lot of fighters starting around 2021 signed what's called class action waivers, arbitration agreements that deny them the ability to take part in a class action. And so when you sign this waiver, this arbitration agreement, you're basically telling the UFC and the court that I cannot, if I want to challenge the contract, if I have a problem with my contract with UFC, I will not go to court. I will go to arbitration, which seems pretty one-sided, right? That's definitely a UFC in the UFC's favor. But because a lot of fighters, basically every fighter from 2021 on that signed a contract, apparently has signed this, that eliminates a large number of fighters from the Johnson class action. So Misha, who does have one of these arbitration agreements, is challenging it under Nevada law. And I'll get back to that in just a second, because there were some discussions in the previous hearing on November 7th that I learned about that are very relevant to that case and why tomorrow will be such a big deal. And then the final potential class action is the Davis v. Zuffa case, where Phil Davis is asking to sue on behalf of basically all non-UFC fighters. And he's not asking for money, but injunctive relief. In that case, the Ali Act, the potential amendment to the Professional Boxing Safety Act, which will gut the Ali Act, that could have implications for that case. So we will get more into that going on the show. But to get back to the primary thing, probably the most important part of tomorrow's hearing coming out of the November 7th hearing, to update people that might not be aware, what the plaintiffs accuse the UFC, charge the UFC, is that they have not been handing over discovery. That the discovery information they've been handing over, the material, and discovery is the material they collected. So in this case, what they want is negotiations between the UFC and fighters over their contracts. And a big reason they want that is that applies to the Cirkunov case, because plaintiffs want to make the case that the UFC abused their monopoly power to force fighters to sign these contracts. And so they want to get evidence of discovery, from discovery, of the negotiations like they had in the Lee case, and then build a case on that. But apparently that the UFC has not turned over much in the way of discovery, and specifically years of text and Instagram or whatever material has been deleted or lost by Tracy Long and Dana White. And so they're saying the Zuffa is not handing over anything over. So the court, the last hearing, basically found that the UFC violated the court's orders regarding discovery and disclosure in the case. And they say that I think apparently they found that they continue to violate the court's order as relates to disclosure. And the court found that the UFC to have engaged in ongoing pattern of discovery violations dating as far back as, I think, over the summer at some time, right? So that's pretty big right there, right? So the hearing tomorrow is they expect the UFC to bring a bunch of material in with them. Now, my understanding is during the last hearing, the judge asked the defendant, Zuffa, the UFC's attorneys, about this, how they had the only material they basically handed over about negotiations was between the UFC and Cirkunov. And the UFC's claim was that they don't really have to hand anything over because of the arbitration agreement. There's no case. The Cirkunov has no case, and that Cirkunov should have to go to arbitration to determine this instead of going to the court with the judge. Now, this is where the fighters should be super fucking happy that they got Judge Boulware, because Judge Boulware and I might butcher this because I was not there, but this is how it was relayed to me. Judge Boulware basically brought up, like, are you telling me under the current law that the Supreme Court ruling, if you're going to cite, I think it was Rent-A-Center ruling precedent, if you're going to cite that, is that no matter what, no matter how much you abuse your monopsony power, no matter that Nevada law, specific law, that it's relevant that if someone offers just take it or leave it negotiations, that should go to arbitration. Even if you're a mining town, I think was the example someone said he brought up. Even if this is a one company mining town, and you had no options but a take it or leave it contract, that the court would have no right to look at this, that this would have to go to negotiations. And the UFC's attorneys basically said, yeah, I think that's the way it should be interpreted. So some judges, and I'm sure, some people think it should be interpreted that way, but that's why the fighters should be thankful that they have Boulware, because apparently Boulware is pushing back on that idea that the Supreme Court has issued a complete ruling on this that even impacts the most obvious abuses of monopsony power, as cited by the example of the mining company town. So to get back, at the last hearing, he was frustrated. Apparently, they hadn't handed over those negotiations. I do not know if the UFC has completely lost that material or not. I think it's possible that they made the determination that they will. One, they could have destroyed it. They could have actually been spoilage and lost all that. And they decided it's just better not to even have it and hand it over. And it's also possible as an and/or that they decided that we are not going to comply because we are just going to challenge this on the fact that Cirkunov has no right to this material. And so that's where we're going forward on that, that the judge will find out tomorrow if the UFC has anything on that. Will he be happy or not with the UFC's answers on that material? There will be a lot he has laid down the law several times. He could issue an adverse finding against the plaintiffs, where that you basically have to assume that the plaintiffs, not against plaintiffs, against the defendants, but you have to basically assume the plaintiffs are correct in all their allegations, which is terrible for the UFC if this ever gets to trial. It's also terrible. The judge could make his ruling on some of these matters himself based on that. So now, why is that important? So that's the next thing. Why is that important to the case? As I intentionally ramble on to save Stephanie's voice here, what makes it important for people listening, if you're a fighter and stuff, is very important for a couple factors. One, if Cirkunov can win and get the arbitration agreements thrown out, well, then that means that the fighters that have these arbitration agreements are now part of the Johnson class action. So if there's a settlement, if they go to court, a trial and win, and there's damages, or there's a settlement like Lee, those fighters who right now stand to get nothing suddenly are included and can get a payout like the Lee class. And that includes probably a lot of fighters that got a payout from the Lee class and have more fights now under Johnson. If they want another check that's even bigger, they better hope he wins. And now thinking about it, on the evidence, if I'm a fighter and the UFC has not provided any negotiation information, I might call my manager and say, listen, do you have the correspondence between the UFC and you? You might want to think of handing it over, which is what the plaintiffs right now are asking Ali Abdelaziz and Dominance to do with their complaint against them and against as they've been asking other managers, hand over those texts, emails, whatever, showing the negotiation process, because that's only can help the plaintiffs win and get you back in as a fighter. That is, get you back into the Johnson class. In fact, I don't know how many fighters negotiate directly with the UFC, but they could do it as well, I guess. But the whole point is you'd want to get as much information on the negotiatings, the negotiations that go between the UFC and fighters that apparently the UFC has lost. So some of these managers who are not sharing that information, not taking part of discovery, if you're a fighter, you might want to ask them and say, listen, on behalf of me, your client, I would like you to hand that material over. And so that the judge could see it and use it, hopefully to determine that the UFC had monopsony power, hopefully, and abused it. So then hopefully these contracts can be thrown out and we can take part in the case and potentially get money. So that's why, just on the Johnson case alone, that's why the hearings are super important. One of the probably the most important things ongoing right now in combat sports, because it could help determine our large number of fighters can be able to take part in the Johnson class action and get money. Let alone, will it help determine Phil Davis, does he have standing to sue? I'm not sure they make that decision tomorrow. I'm sure they'll discuss it, but that's another thing that's hanging in the air. So there's a lot going on with this case, which seems to be ignored by a lot of people. I think that because Lee did not end with injunctive relief, I think a lot of people wrote it off. But even without injunctive relief, the amount of money the fighters could stand to get paid even as a settlement that was similar to the Lee class, but larger because more money's been made, that's a huge windfall to fighters. And so this is super important for fighters on the potential of injunctive relief. Yes. Potential for massive damages. Yes. But even on the potential for some settlement like Lee, this is very important to fighters. I don't think it's quite get enough coverage. I think if you're a fighter listening, you probably want to let other fighters know about it, because this is something they should pay attention to, especially if they've signed these class action waivers, arbitration agreements, because this is something they want to make sure they are not cut out of the Johnson case if they want money in the future from any settlement.
One last question on this. If the judge rules against these arbitration agreements, what does that do for the current contracts of UFC fighters?
Well, if the judge let's step back. I mean, he rules that they're enforceable or they're unenforceable.
Unenforceable.
Well, if they're ruled unenforceable, these class action waivers, arbitration agreements, the UFC is going to appeal it. And it will go to appeal, and there'll probably be a stay on that. But it sets up in motion the idea, it's the first step to saying that these agreements can't be applied. And it wouldn't change the whole contract, but those portions would be ruled unenforceable. And so fighters would no longer have to go to arbitration if they had a dispute with the UFC. They could take it to court. And also, especially if it was upheld by a higher court, which it very well could happen if the UFC does not hand over any discovery at all, right? If there's an adverse ruling by the judge based on the fact that there's no discovery, it's going to be kind of hard I imagine it would be hard for higher courts. I guess it all goes back to, do you think that even in the most monopsonistic situation that arbitration agreements are binding or not? But I imagine if that's the case, I think the Ninth Circuit, most courts would rule with Judge Belwer in that case if he threw them out. And then that would mean that those fighters are now officially part of the Johnson class if it gets made into a class action.
On the other side of the combat sports spectrum, this time for boxing, there will be a congressional hearing about the Ali Act called In Our Corner. What is this meeting about?
Well, the full name, and I'll take blame for this. I think I told you the wrong name for it, but it's In Their Corner, creating more opportunities for American boxers. And what this is a hearing before the Committee of Workplace and Education, where Brian Jack, the representative from Georgia, the Republican representative who introduced the bill, will be a witness to it. That's where it was one of the two places to introduce the bill. It was in two committees, this and Commerce and Energy. And it's it seems like it's a fact-finding hearing on Thursday morning. So this is super important. But as a fact-finding generally, and I think it might be a little misleading, I'd call it a fact-finding. Fact-finding is basically like, we want to just get information. We're not discussing a specific bill because they don't have the bill attached to this hearing, but it seems obvious that this hearing is about the bill. And that kind of raises some alarm bells for me. So it's going to be a hearing about how they can create more opportunities for American boxers. And I'm sure they will bring up the Muhammad Ali American Boxing Revival Act, which I know 100% they're going to bring it up. And they'll have witnesses there. The Democrats and Republicans are both allowed a witness, or both. I should say they both can have someone, I think, as a spokesperson for them. And then there will be 4 witnesses called, I believe, but it's not 3 for the Democrats, 3 for the majority, and 1 for the minority, the Democrats. So that's what's going to happen. Again, super important to pay attention, because as we'll get into the further details, who will be there and all the other stuff and what they'll probably talk about, I think it's worth paying attention how much of this seems like if the fix is in or not. And I think we'll be able to tell during the hearing if the fix is in or not. And that should give us an idea of how quick or how slow this will take through Congress. But it is, again, another massively important event in combat sports, probably not getting tons of coverage. I'm sure people are just more, if they are covering it, they're more discussing, what boxers are supporting it, what are opposed, more of the drama around it, instead of the nuts and bolts of the bill. But the implications are massive for boxing, but also massive, as we just mentioned, for MMA, because I think if the Muhammad Ali American Boxing Revival Act passes as written, it could have implications on the Davis v. Zuffa case, which cites the Ali Act several times in their complaint. And the Davis v. Zuffa complaint is the one where they're asking for injunctive relief. And so if they could change the Ali Act, and it could impact that case, then that would eliminate the threat of the Davis v. Zuffa case potentially. So the implications are massive on multiple fronts here. So there's a lot of moving parts to be paying attention to.
Who will be in attendance?
Well, it's open to the public to sit. I hear Luke Thomas plans to be there. I'm not sure who else, but for the witness part, they're only going to call on a select group of witnesses. There'll be a first panel. And for that panel, I believe usually it's a Republican and a Democrat, but this might just be a Republicans listed right now. Brian Jack, the person that introduced the bill. I think there's a strong possibility the other person on the panel to discuss this publicly with the other members of the committee will be Sharice Davids. I think that's a strong possibility because she's the Democrat and she's the co-sponsor. But right now, only Representative Brian Jack is in the first panel. Then there's a second panel where outside witnesses come in to give basically 5-minute speeches, take some questions that are supposed to be experts that are called in. And the list of people there, and if you notice a trend for 3 of the 4, is 1 is Lawrence Epstein, 2 is Andy Foster, and 3 is Lonnie Ali for the first 3. So Epstein, of course, is the senior executive vice president and COO of UFC. Andy Foster is the California State Athletic Commission, the executive officer. And Lonnie Ali is the widow of Muhammad Ali. And then the 4th person is Patrick English, who we had on the show talking about the bill. And he is a partner at Dines and English and a long-time boxing attorney that's kind of an expert in the Ali Act. So those are your witnesses that are going to be there.
Why do you think there's only one person pitching an argument against the bill?
Well, that's one of the things makes you suggest it might be a fix, is that they have an outcome that they want to see happen, because Pat English is the only one that's opposed the bill. We know Lonnie Ali has already come out in support of it. We know Andy Foster is, I guess the fix is in California. We saw with him. He's a big supporter. And it's hard not to imagine that Lawrence Epstein, who works at the UFC's and TKO and now working with Zuffa Boxing, that he doesn't support it. So the big reason is because the committee names the witnesses, because that the Republicans have the majority, and I'm sure that the word is that there should be support for this. So they've gotten they get to pick 3 people, and they chose 3 people, I'm sure, because they want to tilt it as much as possible in favor of passing it. And Patrick English was the one person that they chose to oppose it because he's very knowledgeable. My understanding is he's been kind of organizing people in the boxing stakeholders to lobby and fight against this. There was some discussion for other people, but there was only one spot given open. So instead of I believe actually someone from the MMAFA was raised as a possibility too, because of the potential implications with MMA. but Patrick English, because he represents boxing, because he worked on the Ollie Act, because he has been a key figure trying to organize some people to contest this. They chose him, but he is as you noted, the only person that's really opposed. I mean, he even opposed at all, I should say, to the bill. The rest of the people are all firm supporters of the new bill.
What about opening the floor for call-ins to be heard? Will something like that happen?
No, there will not be. There will. I mean, they could. A committee member could call someone, but there won't be any phone calls. It ain't open to the public. This is not like the state athletic commission hearings. They have their witnesses. They're each going to get 5 minutes. We should get some paper reports, documents posted before the hearing, as brought forward as like a stance by certain parties. So we'll have that to look at, but really a select few people will speak, and they'll get some questions from members of the committee who probably are not very informed on the subject to begin with.
Well, what comes next after this meeting?
Well, they have the meeting, then not usually, but what could happen, is in the House that there's the other committee, the Energy and Commerce could have a meeting as well. That doesn't have to happen, or they could also come back for another meeting, but that's usually the process. You have meetings, you discuss it. Then there's a process if the Energy and Commerce looks at it, or if there's disagreements over the bill itself, there'd be what's called a markup period where they go through, cross out, and change the bill to make it more suitable to get votes, right? And then the committee would vote on it, put a recommendation, and if they approve it, it would go to the House floor, and the entire House would vote on it. That's the process. My guess, though, thinking that the fix might be on this, that they have lined up the support, because Donald Trump is so close to the TKO entities, that the word came out that he wants them to support this, and that TKO is nurtured through lobbying, donations, whatever, support from various politicians. I'm almost guessing, and we will see, we can watch the hearing and see how it looks to be going, that there will not be a second meeting, and there might not even be a markup period. This bill might be voted on, get out of committee, and go to the floor as is, which would be a tell right there.
Is there anything that might stand in the way of this being a slam dunk for TKO? Well,
the biggest slam dunk possibility or thing to stop a slam dunk was something interrupts Congress again. A possibility always is the Epstein scandal pops up again. We just had a government shutdown that was partly, I shouldn't say that there was, partly due to the fact of the Epstein scandal, partly due to the fact that the House would not sit members of Congress or members to the House. There were Democrats who would vote to release the Epstein files. So that delayed things there. That's why this meeting's happening December 4th instead of November 5th. So that's a possibility. But the bigger one, I think, is if more Republican members of the House resign, and then the Republicans lose the majority that way. Marjorie Taylor Greene's leaving in January, right? Other Republicans in the House have said they're going to step down. Well, if that happens, then there's disarray. There might not be leadership for a while. Nothing might get passed. This might again go to the back burner. And then there's a chance, too, that out of nowhere, if Democrats pick up in the off-year elections, on these special elections, and pick up more seats, that they take control of the House of Representatives, in which case there's a possibility that this is not a priority at all for the Democrats if they take over the House, and then it just sits there and goes nowhere. So that's probably the best hope, is that there's some sort of chaos that happens in the House of Representatives with regards to the House of Representatives. But you got to remember, it goes further than just the House. First, the House has got to pass it, and then someone in the Senate has to introduce it, which I'm sure they got Ted Cruz already lined up to introduce a version. Then the Senate has to pass it. Now, the Senate might be harder because they have to theoretically get over the filibuster, over 60 votes to do it. And there is a chance, even though based on what we've seen so far, there has been no uproar over it. It's got no attention outside of, not only has this bill got only little attention in combat sports, this niche audience, but only a niche of the niche audience has really paid attention to it. So there's a chance when it gets to the Senate, I think, that if it gets picked up by more news outlets.
To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!